Someone make it make sense.
Probably a couple.
Welcome, 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 party squirrels. Come on in. The water is fine. How are y'all doing today on this here Thursday, day off of court from Karen Reed? Shout out to Angel. Shout out to Black Witter. Shout out to Iowa. Shout out to Happy Annie. Happy to see you guys here. Shout out to James, who is probably going to be here in a second. Hope y'all are doing well today. So we have a new filing, well, 3 new filings, but one that actually matters that we can read here for Bryan Kohberger as we continue here, the defense continues their battle to strike the death penalty. And so we do have another order here from Judge Hippler. By the way, after this, we will be doing a recap of Jen McCabe on cross from yesterday. And later tonight, we will be having a little trip down memory lane with Amber Heard on cross exam from Depp v. Heard, because many people, understandably so, have been talking about Amber as we watch Jen on cross. And so I thought that would be fun. And so we will be doing that tonight as well. Welcome, Carla. Happy Annie says, love the lineup for today. Awesome, awesome, awesome. Glad you like it. By the way, I just saw something on Court TV. Apparently, Hulu is making a TV series now on the Murdoch trial, or the Murdoch. Well, I don't know if it's going to be the trial. I don't know what it's going to be, but they're doing a Murdoch show. And I'm like, oh God, I hope that it's not atrocious. Welcome, Truth and Justice, True Crime with Anna. Welcome back, my friend. Happy to see you here. And also welcome, Truth Seeker. We got a lot of truth in the chat. Love it. We're all about the truth. The whole truth and nothing but the truth, as it were. Okay, so let's make it bigger for you guys. Okay. That's what she said. All right. So order on defendant's motion to strike the death penalty and adopt other necessary procedures. And for anyone who's getting here, just reminder, it's harder to read the chat as I'm reading documents, but I try to look over and see what y'all are saying. But just know that it might be a second as we start reading some of these documents, or this document here. Okay. Why? I don't need a summary. Okay. Introduction. Defendant contends that the discovery produced by the state in this case has been voluminous and unorganized, thus rendering him unable to meaningfully review and investigate the state's evidence in time for trial. So this is going to the whole thing about it being obviously disorganized, right? Asserting his due process rights have been violated, defendant seeks sanctions in the form of striking the death penalty and imposing certain organizational requirements upon the state to aid the defendant's view of discovery. We have a couple footnotes here. Boop, 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 boop. First footnote here. Defendant also moved to strike the state's experts, incorporating his motion limine re vague and undisclosed expert witnesses. The court denied this motion in a separate order. And then there's a footnote there from Brady, Maryland. The state responds that it has complied with all discovery obligations, including Brady, and there's no basis for sanctions or other measures. Oral argument on the motion was held on April 9th, 2025, after which the court took the matter under advisement. Because defendant has failed to show a discovery violation or due process violation by the state, sanctions are not warranted. The court further declines to require the state to provide further organizational assistance to the defendant. So basically, we are already getting his opinions right here. I'll read this part again. Because defendant has failed to show a discovery violation or due process violation by the state, sanctions are not warranted. So that's the first thing, no sanctions. The court further declines to require the state to provide further organizational assistance to the defendant. So, one could stop there. Not us, though. Not us. Now we're going to read and see why he has formed this opinion. Welcome, P. Fox. Welcome, Angel again, who's having some insomnia, looks like. And Happy Annie says, I first discovered you when you started doing Amber, Johnny Depp. I lost track of you. You might find me in your chat. Really? That's so funny. Back in the day, right? Wow, that's awesome. And by the way, for anyone who hasn't seen the coverage that I've done with Det v. Heard, one thing that we do is we do all the sidebars. So when they go to sidebar, many times with Amber on the stand, when they go to sidebar, in real time, we pull up and read the sidebars. So we actually know exactly what they were saying. Because of course we don't hear that right in the court feed, but we can read the sidebars. We're so lucky to have those transcripts. So makes it really, gives us the full picture. Standard. A trial court's decision regarding discovery violations must be supported by substantial and competent evidence in the record. Choice of sanctions for a failure to comply with discovery obligations is discretionary. On discretionary matters, and then this is literally, he cites this in every single one of these documents. I'm not going to read it again for the 4 things there. Okay, welcome, Ms. Pottage. Happy to see you again. Analysis. Pursuant to Brady v. Maryland, a prosecutor has a constitutional duty to disclose favorable evidence to the accused where such evidence is material, either to guilt or to punishment. Footnote 3. In a capital case, this includes evidence that may mitigate punishment. Okay. This duty covers not only exculpatory material, but also information that could be used to impeach a key government witness. So just to reiterate, so Brady, right, is exculpatory material. Giglio is your impeachment. And that's why you often hear it Brady Giglio. They'll group the two together. A lot of times people are talking about it's Brady Giglio, right? So 2 different things, but both U.S. case law. And for anyone who hasn't heard us talk about how this works, right? U.S. case law is mandatory binding authority for every court in the U.S. for every jurisdiction. So everybody has to follow it. Okay. Brady does not, however, grant broad discovery rights to a defendant. And they've got some Idaho case law here. This would be from the Court of Appeals, the State Court of Appeals in Idaho. Cite in there, it's quoting a U.S. Supreme Court case law there. And it says an interpretation of Brady to create a broad constitutionally required right of discovery would entirely alter the character and balance of our present systems of criminal justice. And you might wonder why this is situated like this, right? So here's how it is. So oftentimes in case law, right, as we know, when a court is forming an opinion, they're providing case law, right? But sometimes they're providing case law, and that case law is citing other case law. So that's why sometimes you'll have it like this, where you've got, this is Idaho appellate court case law, but in this opinion from 2022, this opinion quotes a U.S. Supreme Court case law, U.S. v. Bagley. So it simply imposes a due process standard upon prosecutors by requiring them to disclose favorable material evidence. Okay. In tandem with Brady, the Idaho criminal rules require the prosecuting attorney to disclose as soon as practicable following the filing of charges any evidence which tends to negate the guilt of the accused as to the offense charged or which would tend to reduce punishment. The discovery obligations under both Brady and Idaho Criminal Rule 16 extend to all government agents having a significant role in investigating and prosecuting the offense. So again, it's not just the attorney's office, right? It's also law enforcement. Defendant complains that the state has, where's footnote 4? Hold on. Here's footnote 3. Okay, we read that one. Oh, we hadn't gotten a footnote 4 yet. Okay, that makes sense then. All right. Defendant complains that the state has failed to satisfy its obligations under Brady and Idaho Criminal Rule 16 due to its methods of discovery production. Footnote 4. Despite presenting this motion in briefing as a Brady violation at the hearing on the motion, defendant confusingly, requested the court view the motion not as a Brady violation, but as a due process violation. I remember her saying that. However, defendant appears to misapprehend the scope of his due process rights regarding discovery. Quote, there is no general constitutional right to discovery in a criminal case. End quote. That's U.S. Supreme Court case law from 1977. In fact, the due process clause has little to say regarding the amount of discovery which the parties must be afforded. Rather, it is Brady and its progeny that serve to uphold a criminal defendant's due process rights with regard to discovery. As the United States Supreme Court has explained, the Brady rule is based on the requirement of due process. Its purpose is not to displace the adversary system and it continues here, let's go find that, as the primary means by which truth is uncovered, speaking of truth, but to ensure that a miscarriage of justice does not occur. Wait, let me read that again. Its purpose is not, and this is a quote from this case law here in Oregon, Supreme Court case law from Wardius v. Oregon. Its purpose is not to displace the adversary system as the primary means by which the truth is uncovered, but to ensure that a miscarriage of justice does not occur. That's interesting, isn't it? So less about truth and more about ensuring there's not a miscarriage of justice. However, one could say, I will say that I feel like not uncovering the truth to me could be, in some cases, also a miscarriage of justice. Just saying my personal opinion on that. Okay, he contends that the state has turned over more than 68 terabytes of data in discovery, consisting of in excess of 13,000 photographs, 15,000 video clips from businesses, and 8,000, missing the comma there, video clips from residents, footnote 5. Other than those identified in warrant applications, expert disclosures, motion practice, and in the exhibit lists, the numerous surveillance videos show nothing of consequence, okay? So he's saying that doesn't really matter in terms of the volume. It also includes more than 60 digital devices. I think it's 67. If Tonka was here, I think he would be able to confirm, because we talked about that at length on a live stream where it was the two of us discussing that a lot. Digital data and search warrant return data. Defendant also contends the state has not provided the discovery in a searchable format, has not provided detailed logs and indexes that would facilitate defense's review of the material, and has not specifically identified any Brady evidence. So we've talked about this before. This comes up in other trials as well. Like, the state does not have the requirement. They're not required yet by any case law, right, or any rule to organize things for the defense. Now, I think many people would agree that it should be required. And having said that, while it is not a requirement, some offices, some prosecuting attorneys' offices do it anyway. For example, EDB has talked about this. When she was the DA for LA County, their office always organized stuff and turned it, even though they're not required to. So they can do it, but they can't force them to do it, right? But they should do it, I feel like, right? Again, they can do it and they should, but they can't be forced to. So defendant argues he has been prejudiced by the state's, quote, data dump, end quote, method of discovery, and contends that sanctions are warranted in the form of striking the death penalty and excluding witnesses. Now, we've seen this again before in other trials where the defense has filed, motions to compel regarding discovery. And the state, and this is what they do, right? The state will be like, well, you want it? Here you go, dump. You asked for it, here it is, dump. And they turn over a ton of shit all at once, disorganized. It's like toddlers fighting. I know you are, but what am I? It's like that, right? Type of thing. That's how I view it. He also asks that the court required the state to identify Brady material or hot documents within its discovery. And Truth and Justice is saying, yes, miscarriage of justice is happening right now in this case. This judge did not go back and look at how many 22 discovery. I think she's saying like motions to compel. Well, that's not an issue here because they made these motions to compel and the discovery was turned over. So now that that's happened, right, what the defense argued as it pertains to these particular grounds for striking the death penalty is they turned it over, but it's really disorganized. We can't find what we're looking for. And it's hard for them to find what they're looking for. That song has come up so many times recently, I feel like. Anyway, they can't find what they're looking for because it's disorganized and it's a massive amount of volume. So you see what I mean? It's this whole thing of like, yeah, they're complying. Here you go, dump, right? While the state acknowledges there is a massive amount of data in this case, it contends the majority is completely irrelevant. Specifically, the state contends that most of the data is from cell phone extractions and weeks of surveillance video footage throughout the Moscow area obtained following the homicides. It affirmed on the record that it is unaware of any Brady material in these videos and that other than those specifically identified in motion practice and otherwise throughout the case. Further, the state's experts who reviewed the various devices, including cell phones and other digital data, have disclosed opinions that they found no connection between the defendant and the victims from the devices and data. Nope, no apologies needed. Y'all don't have to apologize here, I will say. And I hate that. I guess I don't know if other other things, other channels or other things prompt some of you guys, if you know who I'm talking about, like, if I'm talking, we've talked about this before, right? Because it's this whole thing of like breaking the cycle, feeling like you need to apologize. And I'm not saying that's the case with you, particularly Truth and Justice True Crime with Anna, but it is an opportunity to say, you guys don't ever have to apologize for things here. Okay. The state also notes that this case began over 2 years ago, and it has continuously turned over to the defendant all the information it received from the various investigating agencies in the same format as the information was received by the state. So here what Judge Hippler is saying is, well, look, however unfair it is to the defense, it's equally as unfair to the state. That's what he's saying. Footnote 6. The state explained that all the evidence in this case was routed to it from the various investigating agencies. Once received, the state would copy it and then place it directly on the defendant's server in the same fashion and format it was received. The state maintains its files in the same format. So basically, he's like, if it's unfair to the defense, it's also unfair to the state. Which doesn't make it more fair, really. Anyway. It's like saying like 2 negatives equal a neutral. I don't know. Moscow math, right? This was done at the defendant's request. So now he's saying, dude, punishing them for asking for the data, basically, all right? Fuck. This was done at the defendant's request, who specifically asked the state produce everything the state had, in quotes, from the get-go. Wow. He's like, you asked for it. Defendant also issued 400 itemized. I mean, dude, it's just. God forbid they ask for discovery, right? Defendant also issued 400 itemized requests for discovery in this case. Thus, the state contends it is on the same playing field as defendant regarding discovery. Footnote 7. So you may have misunderstood this document. Well, feel free to ask for anyone here in the chat. Feel free to ask any other questions that you have. I will happily answer them to the best of my ability. Okay, so footnote 7. In his reply, the defendant asserted that the state utilizes an expensive, technologically powerful case management software program called Prosecutor by Carpal, which has a global search function to search all discovery and case documents at one time, generate reports from such searches, and automatically transcribe audio and video files. Let me see if that continues on the next page. Yep. Because he does not have similar access to similar technology, the defendant disputes he's on the same playing field as the state. However, at the hearing, the state disputed its evidence software program has any of these features. Instead, the prosecutors rely on a self-created spreadsheet to identify and manage discovery. Interesting. That's something that could be found out, right? Like one could go to this program and find out whether or not it has that search function. Did Judge Hippler do that? Probably not. It's probably taking the state at their word. In addition, the state points out that on September 4th, 2024, at approximately the same time as its discovery deadline, it provided the defendant with a 320-page index identifying the location of requested discovery, a description of the evidence, and the date discovered. In addition, all the evidence received from the FBI, hold on, just a second. In addition, all of the evidence received from the FBI, which comprises the majority, was provided to the defendant with a searchable index. Footnote 8. When defendant ran into a problem with some of the disclosed PDF documents with password protection, the state worked with the defendant to resolve the problem. In sum, the state asserts it has provided everything required by the rule and Brady and disputes that it has engaged in any discovery violations. All right. Subsection A. Defendant has not established a discovery violation, thus sanctions are not warranted. There are 3 components of a true Brady violation. The evidence at issue must be favorable to the accused, either because it is exculpatory or because it is impeaching. That evidence must have been suppressed by the state, either willfully or inadvertently, and prejudice must have ensued. Defendant, as he appears to have acknowledged at the hearing, cannot establish these elements because he has not identified any withheld evidence that is exculpatory or impeaching. Yeah, and they were asked that question at the hearing. Further, he has not identified any obligation under the rules that the state has violated. His quibble, wow. Ugh. You don't have to be rude, though. You know what I mean? His quibble, rather, is with the method in which the state, not to mention, sorry, it just bothers me. This is their job. It's a death penalty case. How dare you, Judge Hippler? Seriously. His quibble, rather, is with the method in which the state has produced discovery, arguing it is effectively a data dump that prevents him from meaningfully review the discovery for Brady material. You know who would never use words like this? Judge, just saying. These are, however, several problems with the defendant's position. First, while neither Brady nor the rule prescribe the form discovery must take, it is well settled under federal law that there is no direct obligation for the government to identify or itemize Brady material for the defense. While the Supreme Court in Brady held that the government may not properly conceal exculpatory evidence from a defendant, it does not place any burden upon the government to conduct a defendant's investigation or assist in the defendant's case. And there's a footnote here. Oh, see also. Brady does not impose an obligation on the prosecution team members to ferret out any potentially defense favorable information for materials that are so disclosed. So again, they're making a distinction between defense favorable information, but not rising to the Brady level. Welcome back, Mac. Oh, that rhymed. That's fun. That's fun. Yeah, he's really taking this tone, isn't he? Mocking them. Yeah, and this is not the first time. I mean, this is further. Voluminous discovery alone is not a basis for finding concealment under Brady. This occurs typically in open file discovery, where the government effectively makes its entire file available to a criminal defendant. Well, that's like what you would see in Florida. This method of discovery, which defendant requested of the state in this case, carries the recognized benefit. Welcome, Tonka. I was just talking about you. That's so funny. Were your ears ringing? Right. Okay. This method of discovery, which defendant requested of the state in this case, carries the recognized benefit of increasing the efficiency and fairness of the criminal process. It is only when the government uses the open file policy to hide exculpatory material or otherwise prevent a defendant's access to such material that a Brady violation will be found. For example, in United States, sure that should say states, Jesus, v. Skilling, the Fifth Circuit observed that while the use of voluminous open file does not alone violate Brady, its misuse by the government can give rise to a Brady violation, stating, by the way, I love doing the little quizzes here. Who wants to let me know in the chat, when you see Fifth Circuit, what court level and what jurisdiction are we talking about? Let me know if you guys have learned anything from me or from anyone else. So stating, for instance, evidence that the government padded an open file with pointless or superfluous information to frustrate a defendant's review of the file might raise serious Brady issues. Creating a voluminous file that is unduly onerous, there's a word of the day, to access might raise similar concerns. And it should go without saying that the government may not hide Brady material of which it is actually aware in a huge open file in the hope that the defendant may never find it or will never find it. These scenarios would indicate that the government was acting in bad faith in performing its obligations under Brady. However, there's no proof that the government larded its production with accurate, PFox. Larded its production with entirely irrelevant documents or made access to documents unduly onerous, a Brady violation will not be found. Here, defendant has not shown any bad faith by the state in regard to discovery production. While the discovery is indeed voluminous, the court does not find that the manner in which the state produced it violates Brady or otherwise constitutes misconduct. The discovery was produced to the defendant as he specifically requested. The state received the information from its investigating agencies, labeled the materials, and turned them over to the defendant through a shared access drive in the same format as received. This method not only puts the state and defendant on equal footing regarding discovery review, it also serves the important purpose of protecting against claims of missing or manipulated documents if the state puts them in a different format or organization or otherwise conveys them to the defendant in a different manner than received. While the state acknowledges that much of the discovery is completely irrelevant, including surveillance videos and data from the numerous phones, computers, and other devices, spelled wrong, Jesus. It did not produce it for any purposes of padding the file or otherwise attempting in bad faith to hide Brady information in its haystack of information. Rather, defendant asked for everything, and everything is what he received. Literally right there, that's exactly what I was saying. I find it interesting that Judge Hippler is like literally saying that, as in he's not even trying to, what's the right way to put this? Minimize or okay, he's basically saying blatantly what I was saying, which is like, I'm surprised to even be reading this, right? As in, you asked for it, you got it type of thing. Like, this is crazy. Wow. I mean, it's almost like saying you should be punished for asking for discovery, and like saying, if you don't want me to come down on you with this hammer, don't ask for discovery. I don't understand. Like, I don't understand how you can punish the defense for asking for discovery. You guys, oh God. Hi, James. I believe I can fly. Oh, I hate that got ruined with everything that went on with R. Kelly, because I love that song. It was such a big part of my childhood. Anyway, wow. Oh, I mean, it's crazy. It's crazy. It's really almost like threatening them into not asking for discovery. And I'm going to keep reading, otherwise I'll lose my mind. Defendant can't demand everything under the sun. Oh my God. Okay, well, that made it worse. That made it, the keep reading made it worse. Everything under the sun. This is so offensive. This is not. Defendant cannot ask for everything under the sun and then complain about the weight of all the planets. Mother of God. Disturbing. This is disturbing. Disturbing. Moreover, defendant has not produced any evidence showing the state has hidden Brady material or made his access to discovery unduly onerous. Although the state did not provide all the discovery in a searchable format, as it was not received by the state in such a format, it provided a 320-page index identifying the specific location of evidence produced in response to the defendant's 400 individual discovery requests, description of the evidence, and the date discovered. In addition, the discovery received from the FBI, which comprised the majority, it was provided to the defendant in a searchable format. Other than the cell phone digital data and the video surveillance footage, defendant has not identified what information his counsel will be unable to review prior to trial and why that information is material. So if he were to do that, they could maybe ask him to reconsider, but I don't know that it would go anywhere considering this judge. But at least he's saying, here's what you didn't do that would have made me less mad at you, maybe. Jesus. Further, the state has stipulated that it is unaware of any Brady material in the video surveillance footage other than that specifically identified in motion practice and its experts who have received all of the cell phone and other digital data in this case and have opined that they found no connection linking the defendant to the devices and data analyzed. Welcome, Angelique. I think you might be new here. Welcome to any new squirrel friends and old squirrel friends. Welcome, everybody, one and all. Feel free to join the Discord as well for anyone who is new. And Tonka, we addressed this a little bit earlier, I think, before you got here. The issue here is not them not turning over discovery. The discovery has been turned over. It's the data dump, right? It was turned over. Here you want it. Here it is. Again, we talked about this earlier. It's so the grounds for this motion to strike death are more about the fact that they have all the discovery, but it's so much, it's voluminous and it's disorganized. And the judge is saying, too bad, so sad. Awesome. By the way, for anyone who's new, we do have some really fun commands. Nightbot put a link in the chat for that, including weather, which is a fun one. We love doing the weather here. Max says, I'm concerned that the defense is giving the appearance that they're stalling. The appearance to who? Like, do you mean to Judge Hippler, or if you want to elaborate on that? So here's where I live. It's 78 degrees. Humidity is 58%, etc. Okay. In addition, the defendant's complaints of being unable to meaningfully review the discovery ring hollow. Again, because they have the discovery. The problem is the volume and it's disorganized. Defendant has been receiving discovery in the same manner for over 2 years. In that time, he's not once sought a remedy from this court to regulate discovery, such as requiring the state to provide discovery in a different format. He has not sought additional resources under the rules to hire additional staff to review discovery. So this is something we had talked about before, right? And I think it actually came up in one of the hearings that they could ask for additional staff. And maybe that's what they should do, right? Hire additional staff to review discovery or obtain litigation document control software to help. Another remedy, like what Judge Hippler is saying. This is fair. Like y'all know how I feel about Judge Hippler, right? But this is a fair point, which is if they can hire additional staff and or probably both, right? I would do both. Also obtain software that will help organize and sort the evidence, right? There you go. But I understand why they made a motion to strike the death penalty first, for obvious reasons, right? They would rather have that option and then find a solution. His lead counsel insisted that she should be allowed to take on a second high-profile capital. Oh, and that hurt. when we got to that part of the hearing and he brought that up, I was like, oof. I mean, that was a point. That was a point. I mean, I think he had a point with that, right? I was surprised to learn that. And I was like, ugh, you know what I mean? I wish she hadn't done that, because now she's giving Judge Hippler and the state other reasons to, as we're seeing here, as we are seeing here, other reasons to say, well, you know, you had enough time for this. His lead counsel insisted that she should be allowed to take on a second high-profile capital case despite the voluminous discovery in this case, footnote 10. Okay, they're just saying something there. Further at oral, wait, what did it say? Oh, the ex parte hearing. Okay. That's how he learned about that. There was an ex parte hearing. Further, at oral argument, lead counsel indicated that her practice is to personally review all the discovery herself. Right. And that was where she said, well, they wouldn't be able to get up to speed and whatnot, right? Rather than rely on associates and staff to review materials to cut through the less relevant information, point to what materials need review by lead counsel. These actions are not indicative of an overburdened defense team. So what he's saying is if she is still able to review it all herself, then they're not overburdened. In fact, it is evident that defendant has been capable to navigate the discovery given his more than robust motion practice, the scope and breadth of the experts retained, and the disclosures filed. In the cases cited by the defendant where courts have struck the death penalty as a sentencing option, the defendant has demonstrated that the prosecution either willfully, note 11, I'm not going to read all that, that's just citing some case law there, or inadvertently, but with extreme resulting prejudice, violated discovery obligations. Let's footnote 12. Oh, and there's the Vallow case. We've talked about this at length and the differences between that case and this case. Again, she'd not waived speedy, and the time that things were turned over was less than a month before trial. Just in summary there. Here, however, defendant has not established a discovery violation under Brady or the rule in the first place. He has not shown that the state has attempted to concealed, should say conceal, not concealed, specific materials within the discovery, and he has not shown discovery to be unduly burdensome to the point where he is unable to examine the items that are material and of evidentiary value, footnote 13. Indeed, the defendant has struggled to identify materials that he has been unable to review at all, except to indicate that the lead counsel has not been able to personally review all the surveillance video and device data produced, most of which the state has conceded are not of evidentiary value and are neither exculpatory nor inculpatory. Well, we all know that relying on the state's opinion of the evidence is useless, and Judge Hippler knows that. So, gross. Consequently, there is no basis for any sanction, let alone striking the death penalty. Moving right along to subsection B. Oh, I did not know that, but actually that's probably, well, no, that can't be what he was referencing. Interesting. I did not know that. Thank you for letting me know. I'll just read the comment on the screen here. Did anyone know there was a hearing yesterday? And yeah, and there's another in May, both sealed. Yeah, May 5th. Yeah, I did not know that. Thanks for letting us know. What do you think here? Katanka says, Anne's also apparently mispertinent, comparable information from the Vallow Daybell cases. Let me know what you think that is, because I can't see anything that is comparable as to what, when Judge Boyce made a very, very thorough finding there, and we've covered that again extensively, I don't see how any of that is applicable here yet. However, if we get closer to trial and other things happen, more disclosures, late discovery, and it's less than a month before trial, then we might be having a different conversation. However, considering Lori Vallow did not waive speedy and Bryan Kohberger did, unfortunately, Judge Hippler might just continue the trial. But at least they would have a better position. They being the defense here, they would have a better position comparing it to that case. Okay, so here we are, subsection B. The court declines to impose organizational requirements on the state. Defendant additionally asks the court to require the state to identify Brady material or hot documents within its discovery, footnote 14. Nonetheless, this issue is largely moot given the representations by the state regarding its knowledge of Brady materials within the discovery and the exchange of the state's expert disclosures and exhibit lists that, from the state's perspective, call out the hot documents. From the state's perspective. Fuck me. The court finds neither is warranted. Oh, right. That's right. I did see there were sealed documents, so that makes sense. Tonka is saying the new hearings are for the penalty phase evaluations the state is demanding for his ASD. Okay. While the general rule is that the government need not specifically identify Brady material within a larger mass of disclosed evidence, courts will sometimes order the government to organize voluminous discovery to comply with the spirit of its statutory and constitutional organizations. Such organization measures include requiring that the government specifically designate any known Brady material within the discovery. We already know what he's going to say here. Whether to order such identification is highly dependent on the facts and circumstances of the case. Courts consider not only the volume of the discovery and how it was produced, but the relative position of the defendant requesting identification, such as 1, defendant's access to counsel; 2, whether the defendant is incarcerated; 3, a defendant's access to resources; 4, a defendant's ability to participate in the preparation of his own defense; and 5, whether the interests of multiple defendants are aligned. In Safarinia, for example, the government produced approximately 1 million records and 3.5 million pages of documents in discovery. Wow. With this discovery, the government provided production logs, bait stamping, and metadata in an electronic and searchable format. The court found that under the circumstances, the government's Brady obligations required it to identify any known Brady material to the extent that the government knows of any such material in its production. And in doing so, the court emphasized that the defendant was an individual defendant who neither had the benefit of parallel civil litigation nor access to voluntary corporate assistance to sift through the massive amounts of documents within the government's voluminous production, that the defendant's counsel was handling the case pro bono with time constraints and limited financial resources, and that the government, assisted by at least 2 federal prosecutors and several federal agents from at least 2 law enforcement agencies, had the luxury of reviewing this material on a rolling basis over the course of his 3-year investigation. I already can see where this is going, because the first things first, I'm the realist. Drop this and let the whole world hear. Just kidding. First things first, it was Brady. So let's see what this footnote says. That's probably what Judge Hippler is going to say. Oh, see also. Okay. I saw the word Brady in that footnote again, just of course. Likewise, in failure, the court directed the government to identify previously disclosed, again, in highlights, Brady Giglio material. The whole point here is there's nothing else that's Brady or Giglio to be identified, according to the state in the voluminous discovery. So Brady Giglio material to the defendant, where the government collected documentary information during a 5-year investigation, and the government's massive production consisted of electronic information with multiple gigabytes and millions of pages. The court reached that conclusion based on the circumstances of that case, which included 1, there was a singular individual defendant who was detained in jail pending trial, and who was represented by a relatively small defense team. And 2, there was no parallel civil litigation, and the defendant did not have access to voluntary corporate assistance in attempting to find documents needed by the defense. By contrast, welcome in Twiz, welcome in Meg. Okay, let me see this. So Anne could have used Balance's testimony during her pursuit of the Franks hearing. From the Vallow Daybell case. We watched that testimony. I just don't know how that would have been applicable for these grounds to strike. You know, they have all these different death penalty motions are based on different things, right? And this one is based on this specific order is based on one specific issue, and that is the voluminous discovery and that it was disorganized. And I mean, I expected this to be denied, right? He doesn't have to be so rude about it, but I expected it to be denied for reasons we've already talked about, right? The case law is clear here. Case law is clear here. And again, while they could organize it if they wanted to, they don't have to, unfortunately. Now, if it's Brady Giglio, they do have to identify that, as we know, but they're saying there's not. So by contrast, in United States v. Meek, the court declined to compel the government to identify Brady material in its discovery. Oh, that's interesting. They didn't compel the government to identify Brady material in its discovery. So you have to turn it over, but they didn't have to identify it here. Noting that 1, the government produced the discovery in a user-friendly, searchable, and indexed format. And 2, there was no indication that the government deliberately concealed or buried any exculpatory evidence in the information it turned over to the defense. And 3, the defendants were sophisticated, formally high-level executives represented by experienced and talented counsel from notable law firms. And 4, the defense had access to discovery for over a year and had it in the same format as, as did the government. So what he's saying here is that there has been a situation where they did have to identify Brady material in discovery, but there were these certain situations, certain circumstances that applied there. That they declined to do that. But again, in this case, and I'm sure this is what he's going to say, is like that they're saying there isn't any other Brady material in the first place. So the court further pointed out that ordering the government to identify or label already produced material as covered by Brady and by omission identify non-Brady material only invites further disputes as to whether the government did an adequate job of identifying such material or characterized the material consistent with the defense view of it. I mean, that makes sense. In other words, it could cause further issues. I mean, I can see how if you're the state or the government, you would argue that. Footnote 16. The holding says that the government was not required to identify Brady material where there was no indication that the government was hiding exculpatory evidence and where its discovery, consisting of several 100 million pages of documents, was electronic and searchable, accompanied by indices and identified hot documents that the prosecution viewed as particularly relevant. While the defendant is currently incarcerated, he has a robust defense team, footnote 7. So now he's going to say he's making distinctions with this versus the other case law, starting with the robust defense team. For capital cases in Idaho, a defendant who has court-appointed counsel must have a lead and a second chair attorney. Here, defendant has always employed at least 3 attorneys, has employed investigators and mitigation specialists, and retained dozens of experts. Let me see what you guys are saying in the chat. Oh, of course. Well, they have to. It's ineffective assistance of counsel otherwise. They have to. They have to make every single motion they can to strike the death penalty. Obviously. I mean, they should, but they're also required to, as we know. Oh, I see what you're saying, Tonka. Thank you for clarifying. Tonka says the comment wasn't made in connection to this document. It was an observation from past events and misses things a lot. Gotcha. Thank you. Thank you. Thank you for clarifying. Twiz is saying no to something. I don't know what. Oh, he's not going to go help Ann Taylor out. Is that what that is? That's funny. Okay. So while defendant is currently incarcerated, he has a robust defense team and has not faced time constraints given his speedy trial waiver, which with this case well over 2 years old. Further, unlike in Safarinia and Salyer, defendant has had nearly as much time as the state to review discovery. Defendant was arrested on December 30th, 2022. Isn't it December 29th, though? I don't think that's correct. I think it's the 29th, right? Approximately 6 weeks after the homicides, defense counsel filed a notice of appearance on January 12th, 2023, and the state first began providing discovery on January 18th, 2023. Thus, this is not a situation where the state has had the benefit of a years-long investigation compared to a defendant who has had mere months to review the investigative material. Further, the court shares the significant concern voiced in Meek that requiring the state to identify Brady material and already produced discovery or to organize it in a way different from how the state received it would simply invite future litigation as to whether the state did a sufficient job. And that's the one I was saying. I was like, yeah, that was when I said, yeah, I think that's a good point, that if you're the government, this is what you would say. This doesn't surprise me that they would say that. And I understand. I mean, I'm sure it's true. Like literally, if you have a death penalty case and you do require the state to organize it in a certain way, you better believe that if there's a conviction that you're going to have the appellate's counsel saying they did an insufficient job. I mean, it just makes sense. That's how this goes, right? That's just how this goes. Not infrequently, what constitutes Brady material is fairly debatable. Yeah. Where the circumstances do not, as here, cry out for departure from the general rule, the court will not invite such future disputes. Right. That's what I thought. Thank you for confirming. Yeah, so he got that fucking wrong. Yeah, Tonka. And I appreciate, for anyone who doesn't know Tonka, we've had a lot of discussions here on this channel in this and other cases about the death penalty. And I remember that when Tonka first started popping up in the chat and joining us here in the School Crew, I remember, if I recall correctly, Tonka was like on the fence or maybe thought it was warranted in certain situations. I just appreciate when all of you guys, and I think it's just an important thing in life to have an open mind, right? And I appreciate that over time. I've noticed Tonka's, not that opinion has to change one direction or another. I think that just the ability to be open-minded is important, regardless of which direction you fall. I just wanted to appreciate Tonka for having an open mind, because I've just noticed his opinion change over time. Okay. In addition, there's no need to require the state to disclose a list of hot documents, which is a tool imposed by some courts for particularly voluminous discovery to aid the defendant in identifying material that deserves closer attention. The state has effectively already done so. The defendant was indicted by a grand jury. This process required the state to present evidence supporting the elements of the charges and identify any substantial evidence which directly negates the guilty of the subject of the investigation. Defendant is privy to all the evidence produced by the state and at the grand jury proceedings in this manner. Further, the state recently disclosed its exhibit and witness list identifying precisely what the state intends to use to support its case. Additionally, the state has taken reasonable steps to aid the defendant in navigating discovery, including by 1, providing a detailed index of all discovery produced, identifying the location, description of evidence, and the date discovered. 2, providing the FBI materials with a searchable index. 3, working with counsel to resolve access problems to documents. And 4, representing the surveillance videos other than those highlighted by the state do not contain any relevant footage, and that the devices, phones, and other digital data of the victims and others do not show any connection between the defendant and the victims. I mean, one could call that exculpatory, though. But anyway, collectively, this provides defendant reasonable means to meaningfully review the discovery he requested. Footnote 18. The court continues to strongly urge the typos. I should say urge, not urges. The court continues to strongly urge defense counsel to request additional resources and personnel from the money judge if it is felt needed. And I agree. I think they should. I think they should do that. I agree. I do agree with that. Get more help. Consequently, the court declines to impose additional organizational requirements. Order. Based on the foregoing, the defendant's motion to strengthen the death penalty and adopt other necessary procedures due to the state's disclosure violations is denied. There you go. There you go, peeps. Welcome, Need Some Z's. Yeah, I believe that's the second time Hippler's gotten the arrest date wrong. He also misstated that Bryan was afforded the right of a Yeah, I remember you saying that before. I don't remember, where was it that he said that? I feel like I would have. Was it said at a hearing or was it in a document? Because I'm trying to remember where that's from, but that is craziness. Meg says people have been really mean to you. I don't understand why people are mean to anybody, but especially you, Meg. I don't get it. Tell me where to find them, and they'll get squirrel karate chopped. Hiya. That is crazy. But you said you're over it. Well, that's good. Be over it, because that's dumb. That's dumb. We don't tolerate that type of thing here. Okay, thank you. Need some Z's. Yeah, we celebrate everybody here, and everybody deserves to be appreciated and loved and celebrated for being amazing. So, but that's it for this document, my friends. So what we will be doing here in an hour is we'll be doing Karen Reed, the recap of Jen on Cross. I have a lot of things I want to talk about there. We may also get into more discussion on the verdict slips, and especially as it pertains to count 2. I've got all the jury instructions. And it's very interesting how when you really scrutinize it, it kind of makes it seem like the third party culprit defense there's a method to the madness there. And it's kind of, by doing that, it's actually changed my view on that. So, but it's hard to explain that without going through it, which we just need to do. And then tonight, for anyone who missed it, tonight we are going to be watching Amber Heard on Cross. Get excited, guys. Oh my God. We're going to watch her cross exam. There's also one of the most disastrous redirects of all time. And then one of the most scorching recrosses. And then she comes back again for rebuttal. It's great. We're going to watch that because there's been a lot of comparison or just discussion about Amber Heard and Jen McCabe and the similarities and differences. And I thought that would be fun and also interesting. It's been a while, so we're going to be doing that. Welcome, Leslie and Billy. So yeah, a lot of people are excited for that, which is awesome. And, the thing is, even if you didn't watch the trial, it doesn't matter. It literally doesn't matter. You will totally, if you've not seen it, right? And even if you have, but my point being, it's not like a situation where you need to know the facts of the case or be up to speed. There's plenty of things that are like that, obviously, where if you come in, you would be lost. That's not the case here. Anybody could come in for this tonight with Amber Heard and be glad they're there. I promise you that. Anyone in the chat that has watched it will, I'm sure, echo that sentiment, that there will be no scroll up behind, because there's no getting up to speed necessary. Really, it is what it is. What is my opinion on Hippler? All of the curse words, I don't even know where to begin. I didn't go today. Lots of face palming. I don't know. I don't. It's like if I start answering that question, we're all just going to get really mad. So, but my opinion comes out with every document and every hearing. It comes out, and I try to be polite. So what you guys hear me saying is like me trying to be polite and respectful and to be objective, because every now and again, well, not even every now and again, even today in this filing that we read through, you've heard me say, yeah, no, I do agree with that, or that's a good point, or whatever, right? So I always point that out. But then there's things that he says and does that I don't agree with, and especially his tone and the things that, yeah, anyway, the mocking of them. And then the thing that really pissed me off especially was like basically threatening the defense, saying it's don't ask for discovery, essentially, which is beyond me. Welcome on in, Toes. Happy to see you again. Twiz is so silly. Yeah, and if you guys got here now, this is not a long live stream. Definitely go back if you want to see the whole document. And when I do timestamps, of course, certain things will be timestamped that I found especially important and or shocking to read and infuriating. All of it's, I always make detailed timestamps. So, but yeah, because it's so short, if you go back on replay, you'll hear certain things where I go through it and give my opinion on certain things. So, yeah, it's again, the certain things that he said in here, we would never have heard from Judge. Never would have heard from Judge and other judges, right? But I loved Judge personally. Is that 6 cups in of coffee? By the way, I haven't had any more cough drops since the other day. Maybe it's time for a cough drop. No, I'll save that for the next live stream. Agree with that. Yeah, I do agree with that, Carla. Everything's always, yeah. It is, I don't like it. I don't like it. It's just too bad Judge couldn't have stayed on this case after the change of venue. So guys, that'll be it for this one. We will be back in about an hour for Karen Reed. Welcome, Cassidy. I hate this when you guys are just now getting here because we're done with this document. But happy that you guys are here. Welcome on in. We got a couple friends here right now from Australia. In Australia. I can't remember. Where are you joining us from, Cassie? I can't recall. I think you're in the US. I can't remember specifically though. Not that everybody has said where they're from or has to, but I always try to remember. Go over the PCA. Why would I go over the PCA? We've gone over the PCA a bazillion times. Why would I? Oh, right. Oregon. I remember now. Thank you. I remember now. Thank you. I remember. That's right. You're in Oregon, just like Kitsmits. Maybe Tonka says if JJ was the judge, we'd still be waiting for the Frank's motions to be heard. Maybe, but you know what? He was way more fair and way more balanced. And I would rather a judge take more time and do things properly, in my opinion. Why would I go over it again? And you guys have all gone over it a million times. What would be the point of going over it again? Everybody here, I guarantee, I can say almost with 100% certainty has seen that PCA a bazillion times. I pretty much have it memorized, but I mean, I'm sure you guys do too. You all don't want to leave. You guys are so funny. Stay. Well, I'm going to be back in an hour. I've got a couple things I need to do before we do the Karen Reed. I'm just going to get some stuff ready and organize all the stuff with the jury instructions and the verdict slips because it's a mess. And get some other things ready as well. So, oh, Twiz. I mean, I could play something and you guys could just be in the chat, but that would just be very weird. Like if I go and get also I need my computer to get things ready, so it'd be harder to do actually. Orchids is members only because not everybody cares about orchids. Even not even all members care about orchids, right? Twist said he'd go live. I didn't see that. You guys are funny. Carla, how's your orchid doing, Carla? Y'all are hilarious. If I can get everything done in sooner than an hour, then I'll be back sooner. But I scheduled it for 1 o'clock. So but if I can come in sooner, I will. So y'all, for anyone who's like, no, what do we do? Like, you guys can definitely check out going back to the beginning of this live stream, for example, like if you missed anything. There's plenty of stuff. I don't need to give you guys suggestions. Y'all are capable of that. And you can also hang out in the Discord, right? If you want to chat with your other school friends, because the Discord's awesome. And I'm glad to hear that good news from Carla about her orchid. I'll put the link in the chat as well for the Discord. James is going to work anyway. Well, have a good day at work. But guys, I'll be back here shortly. Love y'all. Y'all are the best. Love all the Scroll crew. Thanks for being here as always. Thanks for keeping open-minded, being wonderful. Thank you for treating everybody with kindness. And I'll see you guys here shortly.